We are excited to bring to you the next segment, which is a Q&A between Mark Mix, the president of the National Right to Work Legal Defense Foundation and the National Right to Work Committee, and Milton Chappelle, who has been a staff attorney with the National Right to Work Foundation since 1976. Mark works tirelessly for employees' freedom from compulsory unionism by frequently appearing on national television shows, being a guest on nationally syndicated radio shows, and authoring articles that have appeared in national news outlets. Milton is a leading authority on teacher freedom cases and has published numerous articles on teachers' rights. It is an honor to present to you these two leading experts who will be discussing the issues facing many of you and potentially asking the very questions that you have. We hope that you enjoy this great Q&A.
Well, thank you, Amanda, for that introduction. And it's a privilege to be here with Milton Chappelle, one of the veterans of the National Right to Work Foundation organization and our legal program. Milton just started his 48th year with the organization. So he's been around a while, he's seen a lot, and he's our resident expert on lots of issues relating to teachers in the educational sector in the country. So Milton, welcome.
Thank you.
Glad to have you here. It's really always a privilege for me. I've learned so much from you over the years about these issues dealing with teachers and forced unionism. And while your expertise is broad, you have, over the course of your legal career, kind of focused on these issues for teachers and educational issues across the country.
I have.
Yeah. So first of all, let me just start out with a real simple question. I mean, obviously, there are teachers that may or may not want to be part of a union. They may want to get out. They may want to stop dues. Is that something they can do? And we'll get into more detail about how you do it, but let's talk just about that in general.
Sure. That is something that they can do. Every teacher has the right to resign their union membership and to stop their dues deductions if they have signed a dues deduction authorization card. Actually, it's a constitutional right to leave your union whenever you want. But it comes as no shock to learn that unions don't want that to happen. And I found out over my career that when the union is asked a question that they don't like what the person wants to do, they will say no. They will say you can't do it. And unfortunately, a lot of people let it drop at that point. But fortunately, a lot of people come, and our donors have contributed, so the foundation is here so that we can tell the teachers their legal rights and we can push back on that no. So yes, you do have the right.
Okay. But obviously, as you mentioned there, just in passing, there are problems associated with this, and oftentimes teachers run into it. What type of problems have you been experiencing, or what your clients have experienced, or people that make calls to you and ask questions about this?
Right. The biggest problem that we have experienced since our Janus win is that the unions, while they 9 times out of 10 will let a teacher resign their union membership whenever they want, they will say and will tell them that they must continue to pay union dues. And many times they have set up what we call window periods. They've set it up either in the fine print of the dues deduction authorization card the teacher may have signed. They may have signed it when they started their career 20, 30 years ago. Or they have put it in the collective bargaining agreement. And unfortunately, even some states after Janus passed statutes that incorporated these restrictions by law. And so the unions are playing all kinds of tricks with that.
Yeah, I mean, that window period, that escape period is something that I think New Jersey actually legislated a 10-day window. So that means, Milton, if I interpret it, I'm not a lawyer, although I stay at a Holiday Inn every now and then and, get expertise because I hang around with guys like Milton. But the bottom line here is that this window period says that basically your First Amendment rights only exist for 10 days out of the year. And if you miss it, guess what? You no longer have First Amendment rights.
That's correct. So the New Jersey statute you mentioned says that you can do it during a 10-day period in July. Now, the unions, most restrictions are, guess what, in the summer. That the open window period is either July or August, when teachers are off on summer break or not thinking about it. And most of the teachers are thinking about resigning their membership or stopping their dues deductions when they get back in the school year in September and October. And so it's very convenient. The unions have set this up on purpose so that they're told, you just missed the window. You got to wait a whole year. And the union is banking that you will forget.
Well, Milton, on that front, I mean, this is confusing to me because basically you have a teacher that finds out about this. They say, no, I don't want to be part of this anymore. And they stop their deductions. But then that no doesn't carry over to the next period. The unions just ignore that no, even though they have a letter in the file from the employee that says, hey, they don't want to be part of it, even though they missed this 10-day window.
Yes, that is true. We actually are involved in a case for a school employee in Ohio that we are filed a duty of fair representation claim against the union, who when the this happened to be a bus driver, but when the bus driver wrote in and said, I'm leaving the union, I'm stopping the dues, the union says, we can't stop your dues because your request is untimely. And that's all they said. And so the employee went on summer break. They did it in June. So he had no union dues deducted during the summer. He comes back to school. In October, he notices his paycheck is less than it should be. And he then looked at it and saw that the union had deductions, which he thought he had asked for them to stop. So he wrote his employer, says, what's going on? I stopped it. I sent you a letter. So the employer said, well, let us investigate it. The employer then told him, actually forwarded the union's response. Now remember, the union told him it's untimely. When the employer asked, the union told the employer, oh, his window period is the last 2 weeks in August. And so, but of course they told the employer that in October. And so we are filing a complaint in Ohio saying that the union violates its duty, how it has to react to the employees it represents by not telling them when the time is. If they're going to try to enforce this, they need to at least not be able to do a gotcha, just like what you set up here. And instead, remember, he requested to leave in June. He got the letter back from the union in July. Had they told him the window period was August, he would have stopped it and he would not be paying. So he's still, right now, every paycheck, union dues are still being taken out. And we are seeking the help of the labor board and eventually the courts in Ohio to get that money back and to force the unions to at least play fair.
Yeah. Well, Milton, another point you made that's important is you talked about, we've been talking about teachers specifically, but you mentioned this was a school bus driver. These protections, these Janus protections go to all school personnel, and frankly, they go farther than that.
They do.
How far do they go?
They go to every public employee. Okay? I don't care if you work for the city, the state, you're a police officer. If you get your paycheck from any kind of public authority, from government, then Janus rights apply to you. And Janus rights are just simply, I think you all know, but let me just say it again, that you have the constitutional First Amendment right of association, which includes the right not to associate, the right not to speak, to stay away from a union. And government cannot tell you otherwise or force you otherwise. Unfortunately, government is still doing that, especially with dues deductions.
Yeah. One of the things that we hear from a lot of people is, the idea that you have to be a member of the union to get these privileges, and the union has the power for just union members only, and that non-members are somehow going to be excluded. They won't get the coverage of a bargaining agreement. And union officials make a lot of hay with this. Really, I think it's a very thin topical issue of, we're your representative, and if you don't pay us and don't join us, then you don't get these benefits. Talk a little bit about that in the context of this, as some non-members who say, I don't want to be a member of the union, and the union comes back and says, well, first of all, you got to be a member of the union. Secondly, you got to pay dues. That's not true anymore.
That's correct. So again, Janus says you do not have to be a member of the union. You do not have to pay any dues, but the union must treat you the same. They cannot discriminate between members and non-members. And so anything that the government has imposed on the union, what we call monopoly bargaining, anything that the union and the government negotiate and agree to that applies to your bargaining unit. So if you're represented by a public sector union, you get it. They cannot deprive you of any of those rights.
Like
And I
tenure, any of those things.
life insurance, benefits, salary increases, anything in the collective bargaining agreement cannot be based on your membership or non-membership in the union. And clearly, union and union officials go around, stewards and the rest, giving misinformation on this point. They live by saying no and fear.
Well, Milton, we've talked about rights in the workplace, but what about where there is a union? What about workers that want to basically say, can we get rid of the union? Is that a possibility? Is that something that workers can do in the public sector?
That is. All public sector workers have the right to what's called decertify the union. Now, each state has its own laws, and while you have that right state by state, the actual details of how it works and how many signatures and when you can do it and how the elections are held and etc. vary. But the basic right is there. And again, that's what the foundation staff attorneys are here for, to help you. And we actually are involved. I knew you were going to ask me this question. We are actually involved in a decertification election. We hope it will be held before school's out this year, with a charter school in the San Diego area. And this has a fascinating story to it, and I'm not going to go through it all, but this is the second attempt that these teachers have tried to decertify the union. The first attempt was blocked by both the government, the PERB, the politicians in California, by just allowing the union to charge that some kind of employer interference had occurred. And that was good enough. Actually, California law says you do not have to investigate whether that's true or not. If the union says it, that blocks your right. Yeah. And so now we have filed again the window period. There's a window period for that also, has opened up. And we are talking with PERB, that's the government agency who will hold the election, to set a date. And we believe it will go through. And I'm hoping that next year's CEAFU, we can have a very good long report, maybe 15 minutes from the attorney handling that, on the whole story. This is a fascinating story. So I'm teeing this up for next year. Yeah.
Well, Milton, I may have put the cart before the horse, because decertification throws the union out. But there are situations where teachers are faced with the union being in place and then a strike is called. And we know teachers, a lot of conscientious teachers who take their responsibilities very seriously in educating our children, that they're willing and desirous to cross a picket line, but there comes with great trepidation and great traps there. Can you talk a little bit about that?
Right. Again, you have the legal right to work during a strike. Okay. The important thing to exercise that right and to preclude the union from having any legal power over you is that you need to be a non-member before you cross the picket line. The unfortunate situation is that when you become a union member, you basically sign a blank check to agree to anything the union has in its bylaws. And in those bylaws, all unions have a requirement for how a member should act, and they also take upon themselves a power to discipline members for acting not in the way that they want them to act. And unfortunately, that discipline can go as far as to fine the members. And to make matters worse, our courts sit to enforce those fines if they're legally done. So the foundation puts out legal notices all the time for both private and public sectors when there's a major strike going on, going through all the details. It's one where you really need to dot your I's and cross your T's and follow the rules. But if you follow them, you can go and continue to teach your students and cross the picket line legally, and the union has no power over you. The Supreme Court said in a famous decision that the union has no power over non-members any more than they do anybody else out in the street. And that's an important constitutional right to remember.
Yeah. So when it comes to decertification, when it comes to exercising your Janus rights, and when it comes to having questions about what may occur during a strike, foundation attorneys are here to help. Is that right?
That is right. And this last year, and even right now, we are involved in all of those levels.
Yeah. Well, Milton, it really is a privilege. I mean, beginning of 48 years, that's a long career.
Yeah, he's trying to make me feel old.
Well, no, because I'm old too, but well, you're not old. I'm old. But anyway, the point is this. When you started, I mean, the privileges of union officials, the power and privileges of union officials were dramatic. But over the course of your tenure, you've seen really important rights being granted back to individual employees. And, it's easy to get down and to get discouraged about things, but give us just a little perspective real quickly about where it was and where it is and where you think it's going to go. Because I think we're going to win the whole thing and we're going to break forced unionism completely. But give me a sense of that real quick as we finish up here.
Right. Well, when I first was hired at the foundation, whatever number of years ago that was, one of the first cases that I went to the United States Supreme Court to listen to was the infamous Abood case. And under Abood, in the public sector and teachers, and this is what I litigated for most of my career and representing teachers, was the limited rights that Abood gave them. And those rights were limited to just pretty much what the union claimed was the political portion. Yeah. And so they could force you to pay all the rest of the money. And so the basic summary of the end result of Abood is that as a non-member, you had a constitutional right to pay a reduced fee, not equal to union dues, but it was reduced by a very small portion. Mm-hmm. And then you were a non-member. And we fought that for 40-some years, and we kept fighting, okay? My colleagues here, the existence of the foundation, we never accepted Abood. And so it is a crowning moment. It's only going to get better, I agree with Mike, that my career started with the bad news of Abood, has continued to go through the freedom of Janus. It's what the Supreme Court should have done in Abood. And we're going to do even better, hopefully, and I'm working on a case right now that gives a chance to the Supreme Court to throw out unwanted monopoly bargaining totally. So we're moving forward. Things are much better for teachers now than they were when I started, or even for most of my career.
Well, Milton, we're going to force you to stick around until you get that job done. So we'll use compulsion here at the foundation every now and then to keep experts and professionals like Milton Chappelle around fighting for the rights of teachers across the country. It's been an amazing journey. It's been one that is truncated with Supreme Court decisions and a series of Supreme Court decisions that got us to Janus. There's always more work to be done, and Milton is one of the guys leading a group of younger attorneys now that have come in and are filling in spaces and learning from attorneys like Milton and others here at the foundation to basically expand and, first of all, protect and then expand the rights of teachers and public employees and, frankly, private sector employees across the country. It's a privilege for all of us at the foundation to be able to do that, specifically when it comes to the educational issue and the folks that are involved with CEAFU. Milton, I know you've been an active participant in these CEAFU conferences before. Thank you for that. Yep. And thank you for your time today to go over some of these important issues.
Always happy to do it. Teachers are my people. I love CEAFU. As you know, I love giving these reports, and I appreciate all the CEAFU members who keep fighting this on the ground level and give us the cases. Also do not accept the union's misinformation and the no. And together we will continue this fight until victory is won.
All right, Milton. Well, we're gonna demand you come back next year and tell us that victory's been won. So I'll leave that challenge to you. But thanks a lot for tuning in and for the opportunity to talk with you about this important issue.
Thank you.